Good evening to all of you. Today, let's learn the tort law, particularly the topic strict liability. Previously, we learned about the vicarious liability, which says that one person is responsible for the tort done by another person due to the relationship. Now, here we are talking about the strict liability. Actually, this was propounded by Justice Blackburn. Of course, you all know that tort is emanated from the English common law principles. So, strict liability is an imposition of a liability without fault basing on the damages. Please remember, so for committing a tort or tortuous act, you must be negligent. For example, there is no negligence. Right. Second part, there is no intention. Of course, in law of torts, intention may not be necessary. Also, there is no intention, but the result is terrific damage. So, since there are damages, definitely, even though you are not negligent, even though there is no intention on your part, you are liable to pay the damages. This is what is called a strict liability. In India, we call it as no fault liability. Even though there is no fault on you, you are liable to pay some compensation. So, as per the tort law. So, way back in 1860 or so, this has been propounded. Very famous case law is there. Let us discuss that case law. This case law is called as Rylands versus Fletcher, 1868, in which this principle has been evolved. So, now let's go into the details of the case. Small details I wanted to give you. So, Fletcher, he wanted to start a mill for which water is necessary. Please remember, these are those days, 1868. Those days only the mills will work on steam. So the water will be converted into steam and the mills will work. So for getting the water, for reserving the water, he constructed a reservoir. So for this work, he has entrusted the construction of the reservoir to an independent contractor. Who is an independent contractor? He is not directly your servant. You will enter some work with him, you pay some money, he will get it done through his clerks or through his servants and complete the work as designed by you. So that's why you do not have any responsibility to the act done by the independent contractor. So there is no relationship. For a vicarious liability, there should be some relationship. Here, there is no necessity for that relationship. So this work was entrusted to an independent contractor, and he has constructed the reservoir. He has dug out the earth from there. He has filled it with water. Everything is ready. But the important point here to note is that there were some disused shafts underneath the land, and they were taking way to the nearby coal mines. Right? So the reservoir was filled with water. Nobody knows that ultimately on the next day, the water through the disused shafts, they have entered the other persons, that is Rylands coal mines, and damaged the coal mine. Now he filed a case. Here, who is negligent? So Fletcher did not know the existence of the so-called shafts. An independent contractor, of course, he did not take care. He was also not told, and he also did not know. And he has simply completed the construction of the reservoir, filled it with water, and handed it over to the Fletcher. So here, Justice Blackburn propounded three principles and held that Mr. Fletcher is responsible or he is liable to pay compensation. What are those three principles? Now let us know. These three principles are: number one, dangerous thing. Number one, dangerous thing. Ordinarily, we can't expect water to be a dangerous thing. But since he had gone with so much of velocity and damaged the neighboring coal mines, it is stated as a dangerous thing. That's why if any dangerous thing enters your premises, definitely it will be damaging your area, is it not? So therefore, it's a dangerous thing. Then escape is also necessary. Normally, if they fill the water with that, and due to the natural course, if the water percolated to the coal mines, normally nobody will ask you to pay compensation. Because of the disused shafts, because of the existence of those pipes, the water spread away. So please remember, unless the escape is there, they could not be prescribed. This is the escape. Third point is, please remember, this is an important thing. So non-natural use of the land. Non-natural use of the land. So normally, what for the land? His land is there. What for it should be used? Normally for agricultural purpose. Right, is it not? But here he used it for the construction, the commercial purpose. Therefore, when there is non-agriculture, non-natural use of the land, definitely we should have taken more precautions. Since he has failed to do all these things, even though there is no negligence, there is no intention, but still he is liable to pay compensation. So this is briefly regarding the rule in Rylands versus Fletcher or the strict liability. Please remember, strict liability, it is depending only on the damages, that's all. Even though there is you do not exhibit any negligence. Negligence means breach of duty of care. You do not have any intention, but still the damage is done. Therefore, you are liable to pay compensation. Friends, remember, here there are certain exceptions also. If you are able to prove your case in the purview of the exceptions, definitely you can come out. We will discuss the exceptions in the later video. Thank you very much.